Order.
It is the decision adopted by Kenya's bicameral parliament to withdraw from the Rome Statute that shelved the conclusion of the first witness's testimony following the prosecution's concern that it was a development that could potentially impede witness protection.
And I can confirm as I stand here, at least 2 of the witnesses who have been contacted in the week or 2 leading up to the case regarding their participation have specifically referred to this development in the Kenyan Parliament as reasons which have caused them great concern. One of them indicated a concern that if Kenya did in fact go through and if this law was passed, that he would be living in a pariah state in which international law did not apply and he would therefore have no protection.
But it would require a massive stretch of imagination to say that every country that is not a state party is a pariah. The United States of America, India, Russia, China, many noble, decent countries with great heritages are not state parties to the Rome Statute, and they're not pariahs. Pariah countries are countries that are dictatorships, that do not believe in parliamentary democracy, and that suppress the will of the people, not ones that comply with international obligations.
What the Senate and the National Assembly are in so many words telling witnesses and telling victims is that cooperation with the ICC or participating in the proceedings leaves you witnesses, leaves you victims on your own.
I mean, it's completely speculative. Anybody who is in any doubt about the cooperation of Kenya should look at the fact that Kenya, the OTP have a presence there, the registry has a presence there, the defense are operating there. In due course, if the court wished, there may be a side visit to Kenya. This is not a country that is in opposition to the ICC, and nor is Kenya being dragged, kicking and screaming as a naughty schoolchild, to the ICC. The Deputy President sits behind me, not coercively, but because of his belief in the rule of law. Now, these are, as I said earlier, these are inconvenient truths that somehow created a bit of a bump on the prosecution's narrative.
The event of the withdrawal has not occurred.
And that's the fundamental problem with this whole discussion. Kenya has not withdrawn. So putting forward a concern that has not arisen is to push the defense in the position of responding to a hypothesis that is not there. The reality is Kenya is a state party. Kenya even has a judge in this court.
The Deputy President added his voice to the debate, seeking to set the record straight on what appears to him to be a misrepresentation of the country's motive to withdraw from the Rome Statute.
Your Honor, the fact that I am here and the fact that a democratically elected Deputy President of the Republic of Kenya is here is a confirmation that Kenya believes in the rule of law and belongs to the community of nations that are civilized. It doesn't, in my very humble submission, Mr. President, suggest the contrary.
There is specific focus on the sitting president and deputy president and on the indictments that are currently before this court. That, to me, does appear then that there is a very direct nexus between what was done in the Senate and what is before this court.
My client, Mr. Sang, doesn't sit either in the Senate or the National Assembly. This decision was conducted in democratic process that belongs to the Senate and the National Assembly. If it were to be that his rights as contemplated by Article 66, 67 and Regulation 20 to have the proceedings conducted in the open are prejudiced because of the decision of the Senate and the National Assembly, then he will have been prejudiced in respect to circumstances that he has no hand in.
That subject of witnesses and their presentation in court was extensively argued by both sides. The defense is rooting for an open examination of witnesses, an idea that the prosecution cannot consider.
The prosecution, for some unfathomable reason, would have you not look at it, protective measures, in-court protection on a case-by-case basis, but would have carte blanche that we say amounts to a license to lie. Because those witnesses are concerned of two things in my respectful submission. One is they'll be found out and prosecuted. The other is, when the lie is broadcast, maybe we'll get a torrent of new information to the defense that will assist us in showing the court that they're lying.
We're not talking about conducting secret trials here. The evidence will be broadcast. We're talking about limited protective measures, including the protection of the identity, well, the protection of identity and steps taken that are necessary to do that.
It is our position that protective measures in deserving cases should be put in place. However, to adopt a uniform position that the prosecution is suggesting would amount to rewriting the law.
We do not want to run a trial shrouded in secrecy. We want to lift the veil from untruths.
The Chamber is expected to rule on these matters put before it tomorrow. Sylvia Chebet, Citizen Live at 9.